I'm Jeb Butler, and this is Brittany Partridge. We're lawyers at the Butler Kahn Law Firm, and are talking today about our $250,000 car accident settlement. Tell us what happened out there, Brittany.
So this car accident happened in Dalton, Georgia, involved the Rogers family. And we're actually going to pull up a photo of the intersection. So the Rogers family was in a vehicle driving in the southbound lanes of a highway. They were approaching an intersection that was a four-way intersection, but prior to that, there's this road called Rosen Drive. And Mr. Oliver decided to turn left into the north. He turned left into the southbound lanes, which meant he was driving north when he was actually going south.
So the picture we're looking at, this is down Rosen Drive, so the Rogers family would have been going from left to right here?
Yes, that's correct.
Okay, and then we're looking the way the at-fault driver was coming.
Right, so as you can see in this photograph, there is a stop sign and also a no left turn sign on the right.
Mm-hmm.
And Mr. Oliver did not see that sign or ignored it and made that illegal left turn and eventually crashed head-on into the Rogers family's vehicle, which left the severe damage to the vehicle, as you can see in this photograph here, which is the car that the Rogers family was in. It's completely smashed in. The windshield has severe damage, and airbags were deployed, and it was completely totaled.
And then we've also got this police report here. Maybe you can tell us what we're looking at.
Sure. In the police report, you can see the responding officer drew how the collision occurred. So you can see vehicle 1 is Mr. Oliver's vehicle, and he makes that left turn, illegal left turn, into the southbound lanes, and he starts driving north. The two vehicles collide head-on, and it causes both vehicles to spin out and come to a resting place, but not too far off where they collided.
Yeah. And so I can talk a little bit about the traffic ticket that was issued by the investigating officer. So here, as Brittany just described, the investigating officer did a great job of figuring out what happened, and he put it all together and issued a citation, as usually happens to the at-fault driver. We were fortunate in a way that isn't so common in that the at-fault driver pled guilty to the citation. Now, this sort of pled guilty is a legal term of art. When someone gets a traffic citation, they can do generally one of three things, as just like any criminal accusation: plead not guilty, and if that happens, then the ticket doesn't come in to evidence in our personal injury case. The at-fault driver can plead nolo, and if he does that, then the ticket doesn't come into evidence. That means the jury doesn't ever hear about it in our personal injury case. Or the driver can plead guilty, which means that the jury gets to hear about it. And that's, of course, a big deal, because if someone has pled guilty to a traffic citation, you can't very well show up in court and say, oh, no, it wasn't me, or I wasn't at fault, or something like that. So that helped us a lot. It's pretty common in car wreck cases for an at-fault driver to pay the ticket, but not plead guilty. And so in that more common scenario, we don't get to show the jury that the ticket was issued to the at-fault driver and that he paid for it. But here, we would have. So we thought that was a good thing for our client.
Absolutely. So one of the obstacles we ran into in this case was involved health insurance. So in Georgia, we often see health insurance companies claim that they have this right to reimbursement, but there's actually very few health plans that are entitled to reimbursement. But in Mrs. Rogers' case, the mother who was involved in the car wreck, her health insurance company sent us a letter claiming that they were entitled to nearly $40,000 of reimbursement. And so we did an investigation to see if that health insurance plan really did, if it really was entitled to reimbursement. And after multiple phone calls, different letters, reviewing documents, we determined that the health plan was not eligible for reimbursement, or we didn't have to reimburse the health plan. So Mrs. Rogers is able to put all of that $40,000 into her pocket instead of the health insurance companies.
It's something that I feel like proud about, that our firm does a good job of, that a lot of law firms where it's just like paint by number and they don't really focus on their cases don't do, and that is put in elbow grease and hard work so that the money goes to our client rather than to the health insurer. You know, that doesn't increase our firm's fee in the case at all. It just purely helps our clients. I'm always proud that we do that. I wish more personal injury firms did. So here, in order for the final numbers, we had to figure out what insurance was available, and that was a little more complex here than it sometimes is. There was $50,000 in coverage from the at-fault driver's insurance, and of course, they pay first. And then here, there were several different buckets of underinsured motorist, or coverage. And that can come in general from lots of different sources. A passenger may have their own coverage, and if so, that's available first. And if that still isn't enough, then you can find more sometimes based on a policy tied to the vehicle that they are riding in. And if that still isn't enough, you can find coverage based on a resident relative, that is to say, someone with whom the injured person lived and to whom they are related. So if it's a resident relative, you can use that policy. So Brittany totaled them all up, liability and and we came to $250,000 in coverage, and she collected it all for our client. So we ended up with a good case, and I had the client.
Absolutely.